All right, we're going to go ahead and get started. Thank you everyone for joining us today. For those joining us on Zoom, thank you for logging in. For those watching this recording afterwards, hope you're having a great day. I'm Meredith Badler. I'm the Deputy Director at the CBCA, the Colorado Business Committee for the Arts. And we are excited to bring you this presentation today on setting up a business that protects you, thinking about business entities, LLCs, and insurance, particularly for creative businesses, our artistic entrepreneurs and creative small businesses. This webinar is being presented as part of CBCA's Colorado Attorneys for the Arts program, or CAFTA, as we call it. CAFTA is a legal referral service that connects limited income artists, creative businesses, cultural organizations with free legal help. And then we also offer trainings and webinars and workshops like this today, as well as in-person ones, to provide really vital legal education to our creative industries. So we are being joined today by Allie Moore, who is one of those attorneys who works a lot in the creative industries. So that's what we're going to be talking about. A few housekeeping items as we get started. This is being presented on the Zoom webinar platform. So for those of you who are watching live with us, you are muted, your camera's turned off so we can really focus on the content. However, that doesn't mean we don't want to hear from you. We know you probably have questions, maybe specific to your work or the things that Allie is talking about this morning. So please use your chat to send us some of those questions, comments. There's also a very nifty Q&A feature, which is a great way to shoot us over some questions. And I'm going to invite you as we get started to open up that chat feature and introduce yourself. You can send that message to all panelists and all attendees, and that will give us a sense of who's joining with us today and what your role is. So feel free to introduce yourself. We'd love to say hello and let you all know who else is with us this morning. And we are recording this webinar. It will be posted afterwards on CBCA's YouTube channel and on our website for future reference, which is a really wonderful thing we're happy to offer. So with that, I'd love to introduce our speaker today, Allie Moore. Allie is an attorney. She works with lots of small businesses, particularly ones in the creative industries. She has her own law firm, which really focuses on that specific population. And she's also a creative herself. She also has her own photography business. And I'm sure she'll say more about all of those things, but we love at CBCA when we get to work with people like Allie that really understand the creative industries because they're in it as well and can bring this professional legal expertise to you all too. So I'll stop sharing my screen, turn it over to Allie. She'll lead us through this presentation until just about 11. Again, find your chat, find your Q&A on your Zoom platform, and send us your questions, comments. We want to hear from you and really make sure this content serves your needs. So take it away, Allie.
Thanks, Meredith. Yes, so my name is Allie Moore. I am a small business lawyer, and my law firm is called Creatives Learn Law. We serve primarily creative small businesses. Obviously, it's a lot of artists, graphic designers, photographers, and then my partner serves a lot of wellness professionals, therapists, yoga teachers, people in that line of work. So I actually started my career in my professional life as a wedding and portrait photographer. And this year I am closing our wedding and portrait photography business after 10 years of operation. It was just time. COVID really helped. I'm sure a lot of you guys have experienced how challenging it is to operate a creative business this year, especially one that relies on in-person interaction. But that means that my experience as a photographer and as someone who owned a very small business, because a lot of creatives own very small businesses, the size of businesses that I think lawyers sometimes forget need legal services, that informs my practice. So my presentation today is targeted at people like that, people who have really small businesses, and they are often overlooked when it comes to presentations about business law. When I attended the Colorado Bar Association's Business Law Institute last year, it was great. I learned a ton, but it was focused all on corporations and on people who are receiving venture capital and who are otherwise looking for financing. And that's a really complicated area of law, and that's an area of law where a lot of people need to hire lawyers. But most of my clients don't need that. Most of my clients need help with entity formation, with getting their contracts in order, and with understanding the basic ways that they should protect themselves from liability. So that's what this presentation is focused on. It's focused on very small businesses. I'll speak briefly about nonprofits because I think there were some nonprofit registrants as well, but mostly focused on small business, because I think that is a lot of creatives and the kinds of things you can do to protect yourself from liability in that type of business. So I'm going to go ahead and get my screen share set up. Okay, so before I jump into the body of my presentation, I'm going to give you guys an overview and a disclaimer. So I'm going to start by just talking about the different types of liability that we're worried about. And I'm going to look at the chat right now just to make sure that I don't need to do anything, that everybody can hear me. I don't need to do anything. And then I'm not going to look at the chat anymore. So I'm going to rely on Meredith and Rachel to alert me if I need anything, because otherwise I get yeah, it's tricky to manage both. So thanks, Meredith. Says I look great. I will trust that somebody will cut in if nobody can hear or anything else goes wrong. But so I'm going to start by talking about the different types of liability that small businesses are concerned about and that creatives are concerned about. And then we'll talk about limited liability entities, how to form them, how to maintain them, and what they do and don't protect you against. And then after we talk about that and what gaps limited liability entities still leave for a risk exposure, we'll talk about insurance and using contracts to help cover those gaps. So the disclaimer that I have to give here, that any lawyer ever will give before any educational presentation, is that this is all general information. So the difference between general information and legal advice is that legal advice is what happens when you listen to someone's situation, you process their situation, you apply the law to their situation, and you tell them what to do. This is not that. This is just information about the law, information about how the law works. But if you need advice for a particular situation, that's when you need to work one-on-one with a lawyer. So I absolutely welcome all of your questions. It's really helpful when you ask your questions if you can keep them either hypothetical or just informational, as opposed to giving me facts about your life and then asking me what to do, because I can't answer those questions in a format like this. So all that being said, let's talk about liability. I should warn you, my PowerPoint skills are weak, and that's kind of sad in 2020, but I did try to add a couple pictures for you guys because I know that this content is dense. So there are two types of liability that we want to think and talk about, and those, sorry, I've got somebody coming in the room too. There's the two types of liability that I want small business owners to be aware of are contract liability and tort liability. So contract liability is the kind of liability that arises from an agreement, like with a client or with a vendor, but there's an agreement between the two of you to exchange goods or services for value. There doesn't have to be a formal written contract, but there does have to be some expectation that you have a bargain. You guys are both going to provide something and you're both going to receive something. And those kinds, that kind of liability exposure is typically easier to manage and more affordable. So for example, especially for creatives, that's not so true like in the construction industry, where you may have hundreds of thousands of dollars in contracts, and if you mess up, you affect a bunch of other contracts too. But for creatives who are providing like a personal service or doing an art installation, if something gets messed up, their contract exposure, their risk is typically just about as much as the contract was for. On the other hand, the tort liability and tort risk can be really expensive. That's personal injury is what I mean when I say tort. So I included this example of this hot coffee lawsuit that people love to talk about because that was a lawsuit that involved punitive damages. And punitive damages mean damages that are meant to punish the person who did the wrong, who committed the tort. So in that case, McDonald's didn't turn down the coffee temperature, even though they knew that their coffee was too hot and that it was burning people. This woman experienced really severe burns. She gets awarded millions of dollars over hot coffee, and we all talk about how silly that is, but that's a really good example of punitive damages, damages meant to punish, and that is one reason why personal injury risk can be so expensive, because those kinds of damages are allowed. Personal injury risk is also so expensive because healthcare is so expensive, and if someone is injured and you're on the hook for their medical bills, really big deal. So in general, tort is more expensive than contract liability. And when we think about contract and tort liability, that's going to sort of play in to each of the next topics that I talk about. These aren't the only kinds of liability. Another big one for creatives would be intellectual property liability, so the risk of misusing someone else's IP. But these are kind of two of the really big buckets of the ways that you have risk exposure when you operate a creative small business. So that foundation being laid, I'm going to talk about entities. So an entity is what exists when you decide to take your business and go to the Secretary of State's website and file a form that says, my business exists separately from myself. So lawyers talk about corporate personhood, and if you've ever heard anybody complain about Citizens United, they're talking about corporate personhood. And what that means is that an entity, not the people who operate the entity, has rights. And most importantly, for our purposes, entities have contract rights. So the reason that having an entity with contract rights protects you is because your entity can enter into a contract and can be bound to all the obligations on the contract instead of you as an individual. And your entity only has assets that are in the entity. So if your business, let's say you're a photographer or a filmmaker and you own some cameras and you own some computers, and all of those things belong to your business. So those are your business's assets, but your personal home, if you own your home, and the equity in your home are your personal assets. So an entity allows you to maintain separation between those two things. And it means that if someone sues your entity because your entity was on a contract and your entity breached the contract, or your entity allegedly breached the contract, then in that lawsuit, they can only recover the things that were in your entity, the business's property, and they can't reach your personal assets. However, this is one of the big reasons I start with the distinction between contract and tort. Individuals that commit torts, that commit those acts that result in someone else getting injured, are still liable for their personal acts. So most of my clients are either solo entrepreneurs or maybe partners in an LLC, and they don't have employees. They have a couple of contractors, but really a lot of the business, they're handling all of it. They're out on the work site, installing the art or photographing the wedding. And so it could be, if you're in those situations and someone is injured, that doesn't mean that your home is protected from that personal injury lawsuit. What it does mean is that if your business, the business itself signs a commercial lease and your landlord doesn't require a personal guarantee, it just allows your LLC to sign the commercial lease. Then if you default, you don't pay your rent, the only money that your landlord can get back is what's in the business. So that's when an entity protects you and helps minimize your personal risk exposure. But you can see that it absolutely is not complete protection, and it definitely doesn't do everything that most of my clients need it to do. And at this point, when I give this presentation, I think a lot of people that I talk to who really don't have they don't have commercial leases. They don't have a lot of expensive contracts that they're worried about breaching. And they're wondering, why did I even form an LLC? I don't really have that much contract liability. All I have is, these $5,000 and $6,000 contracts for graphic design projects. And if I breach those, I can figure it out and give my client a refund. That's a good point. That's true. An LLC isn't doing a ton for you, but look at how easy it is to form an LLC. It costs $50, and it takes me about 7 minutes on the Secretary of State's website to create an LLC. Maybe, if you're new to the Secretary of State's website, it takes you half an hour to Google and figure out and make sure you're doing everything correctly, but it's really, really easy. And then after you've spent that time on startup to create your LLC, you just need once a year to spend $10 to fill out a quick report and file your periodic report with the Secretary of State annually. And you have to keep your finances separate. You need to keep your business money in your business bank account. And when you pay yourself, you need to document that. So money that goes in and out of your business bank account should all be documented through a good bookkeeping process. And when you sign contracts, you need to bind your LLC instead of you personally. And if you do all of that, then you're taking advantage of the LLC protections. So even if they're pretty minimal on the cost benefit analysis, it's so easy to form an LLC that almost everybody that I talk to, I recommend to them, if they have not formed an LLC, that they just take the time to go ahead and do it, because there are some protections. And so it's worth that effort. Corporations and nonprofit corporations, and there are actually a bunch of other types of entities, but these are really the big ones. Same exact liability protection. If you have a corporation or a nonprofit corporation, they just have more complicated requirements for maintenance. So instead of just setting up your articles of organization and paying the filing fee, you have to have a board of directors, you have to have bylaws, you probably have to have a shareholders agreement, you need to store books and records at certain places. So most of my clients do not benefit from having a corporation. I do work with some nonprofits. And obviously the reason people have nonprofits is to take advantage of the IRS benefits. But largely people who benefit from corporations are people who are expecting some kind of investment. So venture capital, or they're trying to sell shares. Otherwise, most small businesses are best served by an LLC, depending on the facts and situation of your business. And I will just briefly say that people who want to take an S election, and an S election is a tax benefit as well. And S elections help a lot of creatives when they're earning enough money to pay themselves a reasonable salary, and then to also pay themselves profits. And then those profits aren't subject to payroll tax. People who want to take advantage of that tax benefit, they can still have a state level LLC. They don't need a state level corporation. Even though it's called an S corporation, you can make that election as an LLC. So if that's something that's on anybody's radar, I just want to let them know that they don't have to have a state level corporation to do that. Meredith or Rachel, any questions or anything I should be aware of before I go on?
Yeah, there was a great question. Thank you, Shauna, for sending your question through the Q&A. Keep them coming. She says, when you sign contracts, do you need to sign your name and also member in order to bind your LLC? So I think that it's a great question about sort of how do you act on behalf of your LLC? And I know I will add another question to this about, do you actually need to put LLC in the name? So
yep.
There you go.
Great questions. Okay, so I'm going to start with that last question. So the statute does require that the name of your LLC either has LLC, limited liability company, LTD period. There's a list of like 8 or 9 different things that you can include in your LLC's name, including the full limited liability company. But LLC is easiest for most people. And then, so you need to include that indicator in your name when you create it. If you forgot to do that, you can fix it. It costs $15 and it's pretty easy to fix it. So you need to include LLC in your name. When you refer to your entity in your contract, you want to include LLC or limited or whatever you did in compliance with the statute. You don't need to put that LLC or limited on your branding. So you don't need to go, you don't go to Target's website and see Target Corporation everywhere. It doesn't need to be everywhere, but it does need to appear to people before they agree to enter into a contract with you. So in your contract, you want to use your LLC name. And yes, Shauna, that's exactly how I advise my clients to sign their contracts. So my law firm, is actually, the entity is named Allie Moore Law, or Allie Moore LLC. I can't even remember. It's named Allie Moore LLC because I started the law firm before my partner joined me, and we just put a DBA on top of our LLC. So our DBA is Creatives Learn Law. A DBA is a way to inform people that you're using a fictitious name, right? So when people see Creatives Learn Law, they could go to the Secretary of State, look it up, and see that it's our LLC, Allie Moore LLC, that's behind it. So when I sign a contract, I sign Allie Moore, comma, member, comma, Allie Moore LLC, DBA, Creatives Learn Law. And the reason you put member in between your name and your business's name is because that is that's the agency relationship between you and your business. That's the relationship that gives you the authority to bind the business. You can put owner. Member is typically more advisable because but everybody knows that that means that you're signing as a representative of your LLC. People's concern with owner is that it could be interpreted to mean that you're signing as the person who owns the business instead of as the representative of the business. So member is the safest way to go. And you don't want to use like your job title. Like you don't want to say Allie Moore photographer. Our business is called Woodbox Studios. You don't want to do that. You definitely want to sign in a way that shows your agency relationship. So if you have a job title like president or CEO because you have a corporation, you use that, but member is the easiest and safest bet for LLCs.
I have a follow-up question. I have two more questions. If you're an LLC with an S election, do you still sign member or are you an employee now? And I know you mentioned S election, but I think maybe recapping that and then answer the question.
Yes. So just as a reminder, an S election is an IRS designation that changes the way your entity pays federal income tax. You still say member because you are an employee, but the reason that you have authority to bind your business is because you're the member, not because you're the employee. So in every business, there's ownership and there's management. And for solo entrepreneurs, ownership and management they're the same person, right? Unless you have some sort of angel investor that owns your business and you're actually doing all of the work. And anyway, typically the owner and the manager or the member and the manager are the same person for most of my clients. When you have an S corp, you have to put yourself on payroll because that's what you need to do to take advantage of this tax system. But you still are binding your business as a member as opposed to as the employee. So still put member when you sign those contracts.
Super, that's really helpful. And then you mentioned earlier about keeping finances separate.
Mm-hmm.
Can you explain a little bit more about what that looks like or tips to help people manage that? I know that's sort of a common issue, especially as you said, you're the owner, you're the manager, you're the employee, you're a person.
Absolutely. So the first thing you have to do to keep finances separate is after you've formed your LLC, you have to go to the IRS and get an employer identification number, an EIN. It's free. Again, it's a process that is very quick and easy for me, maybe 10, 15 minutes on the IRS website. And that's the equivalent of the social security number of your business. And the reason you need that is because you can't open a bank account without it. So you've got your articles of organization that you filed with the LLC. You have your EIN from the IRS. Now you can open a business bank account. You open that business bank account and then you set up every deposit that's a client payment or a contract payment or income from the sale of a product. It all goes into your business bank account. Every time that you pay a business expense, you use your business debit card or your business credit card or your business checkbook, or you pull out cash and you keep a record of the cash, the petty cash that you used from your business account. But everything goes in and out of your business account if it's a business expense. We all mess up sometimes and forget our business credit card or accidentally use our business credit card to buy our Taco Bell. I've done that plenty of times. When you do that, you just need to document it. You need to, if you use QuickBooks or Xero, or if you use a spreadsheet, you just need to make a note that says, oops, went to Taco Bell, grabbed the wrong credit card, and then you record it as basically a payment to yourself. Like that Taco Bell that I bought was a member distribution. You're gonna be taxed on that because it's money that came out of your business to use it for personal stuff. Everything that's tax deductible and that you record, then that money offsets your tax liability at the end of the year. And then every time you pay yourself, that's called in an LLC a member draw or a member distribution. You just record it in your ledger. You say, I paid myself profits, or I paid myself on payroll on this date. And if you ever put money into your business so that you're making an investment in your business to buy something, same thing, you just record it. So it's all about record keeping. And I will just say also that we waited probably 7 years before we hired a bookkeeper. And then I paid that person like $50 a month because our bookkeeping was so simple. And I hated that I waited 7 years to do that. So if you don't have a bookkeeper and $50 a month sounds manageable, because a lot of it is, people charge various amounts and different people have different levels of complexity. So I'm not saying that's the across the board price, but because it's so easy to automate so much of that using something like QuickBooks or Xero, bookkeeping is pretty affordable. And it's one of the first things that I recommend people outsource.
So helpful. Thank you, Allie. We did have Colin ask sort of a follow-up question about, can you use your social security number to open a business? Do you need an EIN?
So if you use your social security number to open a bank account, then the person who owns that bank account, or I'm going to say person again, but it's you, the person who owns the bank account and not your business. Typically, like you maybe have opened a personal account that you maybe put your business's name on internally, but because when people look at entities and they look to see how protected you are, in terms of that, when I talked at the beginning about how if your entity gets sued, they can't get your personal assets, what they're looking for is separation between the entity and the owner. And so using your social security number to open your business's bank account is not good for that kind of separation. So definitely preferable. I'm not saying that it's fatal and that they're going to say, oh, you don't get the limited liability protection, but I would not advise it. I would say that the best option is to get the EIN and to make sure that your business's bank account is affiliated with the EIN.
That's all we have. I think keep the questions coming, folks, and we'll keep going.
Excellent. Thank you. I really appreciate the questions. I also teach at the law school, and I can't tell you as a professor like how mortifying it is to talk for like 45 minutes and have no one ask about anything. So thank you for participating. It makes me feel a lot of energy. So because the liability protection that comes along with having an entity is not complete or perfect, and it doesn't meet everybody's needs all the time, I also really recommend that all small business owners have insurance. Or at least all small business owners that are actively doing things. If you just have an entity that sits there and you don't actually do anything, insurance may be not important. But as soon as you start doing things, and by doing things, I mean entering into contracts, providing services, accepting money, I really, really want my clients to have insurance. So much so that like when people call me to write a contract for them and they don't have insurance yet, I tell them to buy the insurance first and then to go back, because I want them to use their money in a way that protects themselves appropriately. So there are different types of insurance policies that businesses might be interested in. The big one that typically business owners start with is commercial liability. I worked with an insurance broker to give a presentation, a commercial broker, a few weeks ago, and he called this slip, trip, and fall coverage. And I think that's a really good name for it. This is the policy that's going to protect you if you have a physical location or if you meet with clients somewhere else and they get hurt because of the way that you maintain the location, or because when I work with photographers, I always say, if you pose somebody and you ask them to stand on a rock and they fall off the rock, this general commercial liability, that's what's going to protect you in these situations. These policies typically have like coverage limits in the $1 to $2 million range. And that it's because these are expensive claims. If something goes wrong and somebody does get hurt, you could need hundreds of thousands of dollars in coverage. Professional errors and omissions, on the other hand, is more of a kind of coverage that would help you in a breach of contract. So you didn't deliver on the services you were supposed to provide to your client, or your, the product wasn't made with the degree of professionalism you promised. Then an insurance policy that protects you as a professional is also helpful. I worry less, especially for my clients who are photographers, graphic designers, wedding planners, filmmakers, people who provide these personal services where there's actually not a lot at stake beyond the project itself. I'm not so worried about them carrying errors and omissions insurance, because if they messed up, and this is what I asked them, if you really messed up your client's work, could you issue them a full refund? Like, that's probably going to be what you would need to do. And so errors and omissions can still be helpful for someone like me, a lawyer, where if I mess up a deal, it could result in my client experiencing hundreds of thousands of dollars in loss. Or a physician who commits medical malpractice could take somebody's life. They really need professional malpractice insurance. It's usually pretty affordable for my clients. So if that's something that people want, I definitely wouldn't discourage them from getting it. But general commercial liability is the most important, and also general commercial liability is often required when you enter into contracts, like as a subcontractor, or if you were going to do a public art installation, work with a big corporation, work at a particular wedding venue. They often want to see your proof of commercial liability insurance, so you need it. Just so you can enter into partnerships and collaborations with people. There are other kinds of policies out there, electronic media, things that protect you against data breach. If you have employees, there are a couple of different kinds of insurance that you certainly want and need, like workers' comp, employer's liability. Most of my clients don't have employees, but I do like to flag that for people, because a lot of small business owners are hoping for growth in the future. So even if you don't have employees now, keep in mind that when you onboard employees, that's going to change a lot of your regulatory requirements, and you're also going to need to take that time to reevaluate your insurance. And then tools and equipment is going to be, that's a lot of my clients are concerned about that the policy that covers, like, if your camera equipment gets damaged, if your computer gets damaged, your potter's wheel, all of that. When you buy a tools and equipment policy, make sure you read really carefully what the deductible is, what the limit is, if they do replacement value, or if they, take what your item was worth based on its age and give you half of what you thought you needed. So tools and equipment, I just like people to read carefully, because sometimes you pay for a policy and then you're like, wait a second, I'm not going to use this policy because the deductible is too high. So anyway, I think there was a question, Meredith, is that?
Yeah, there was a question it's a question and a comment about there isn't really artist insurance. The gentleman here gave an example of, I have to get insurance for public projects, and when I do, it goes under him as a metal worker or a woodworker, and not really acknowledging an artist as a profession. Are there policies out there that may be sort of specific to some of these creative professions?
I haven't seen, what I have seen is food. So I consider food to be a creative, cake baking, catering. There are food specific policies. I have not seen artist specific policies. What comes to mind immediately for me is like public art. And I do know that there are insurers that work specifically with municipal projects, that would maybe be a good choice if you had a government contract for an art installation. But I think that's probably right. Most of my clients who just provide creative services have like a really general commercial liability policy, and their rate is based on their profession, but it's not, it's not written in a way that's specific to their business.
And then I know you mentioned sort of nonprofits at the beginning.
Mm-hmm.
Is it worth mentioning sort of D&O, directors and officers policies? How does that maybe fit?
Yeah, so nonprofits, so corporations, as opposed to LLCs, like they have a board of directors, and director liability and officer liability is a little bit different than just your general commercial liability. So a D&O policy would be like a board policy. So if you have a nonprofit board of directors, you probably want insurance for your board members in case there's any sort of a lawsuit against the nonprofit. And then it'll also say on the nonprofit front, that if you're providing services that involve kids, there's insurance policies, like if you're providing services that involve kids in any capacity, whether it's nonprofit or a business, you want to talk to an insurance agent about policies involving, like, claims involving supervising and being around kids. So especially for nonprofits, like, there are policies that cover claims of sexual abuse, and that stuff is important for nonprofits to think about.
I think that's it. We'll keep going.
All right. So contracts, I guess actually now that I'm on the contract side, I will say one more thing as a final note about insurance, which is that every insurance policy is a contract. So I just spoke in broad generalities about different types of policies, but with the exception of health insurance, which is now highly regulated and has to cover things in a certain way, every insurance policy is a little bit different. So you need to read the policy or talk to your agent. It's really hard for me to even read an insurance policy. So talk to your agent about your questions to make sure that your insurance policy provides what you think it provides and at the dollar amounts that you're expecting, because you could look at a couple of different policies that have totally different coverages. So other kinds of contracts, the kinds of contracts that you use with your clients or with your vendors, contracts are really important to protect you from liability in a number of ways. I'm going to talk about a couple specific clauses that are about liability and risk, but even just operating with a contract is an important way that you protect yourself from risk, because you're taking the time to set expectations between the two parties, and especially if it's a well thought out contract that you've been really intentional about, that it's going to cover contingencies that could arise. And without a contract in place, there's just a lot more confusion and an overall a lot more risk. So often when you get an insurance policy, one of the questions that they'll ask when they rate your risk is, do you use a contract with every client? And just they don't even look at your contract, but just the fact that you're using a contract makes them think your risk is lower, because you're taking the time to formalize the relationship, which is an important part of liability protection. So that being said, I'm going to talk about contract provisions that specifically limit liability. Contracts have they do a couple of jobs, and one of the big job is that they set out the terms of the deal and who expects to get what from who, when, and where. They answer those big questions about the deal, but then they also allocate risk, and they say who's going to be on the hook if things go wrong. So 3 kinds of contract provisions that limit liability. The first is liquidated damages. So a liquidated damages clause protects you from contract liability or limits your contract liability. Liquidated damages clauses are clauses that say if there is a breach of contract, then the most or the amount that people are going to be on the hook for is X dollars. I'll show you 2 examples on the next slide. Something to keep in mind about liquidated damages clauses is that they aren't always enforceable. So the general rule of contract law is that if the parties intended it, a court will enforce it. But there are some limits. We can't enforce illegal contracts. Like, a court would never enforce a contract for the sale of drugs. There are also, with sale of illegal drugs, there is also a limit on liquidated damages. So provisions like this, where they say if somebody messes up, the amount of money that they can recover, or that the other party can recover, is $X, only enforceable if there's clear intent on the behalf of the parties to enter into that agreement, if there's a reasonable estimate of damages, and if at the time you sign the contract, it's difficult to predict what a breach would cost. So I'm sorry, I talk about photographers all the time because it's really top of mind for me. But in a wedding photography contract, for example, those images, if a photographer messes up and can't deliver images of a wedding ceremony, those images might have a lot of emotional value. And it's not really clear how much somebody should be entitled for that kind of loss. So a lot of wedding photography contracts limit the damages. And I'm going to the next slide, and I'm looking at this second clause here, that it limits the damages to the contract price as set forth above. So this is a really common liquidated damages provision for creatives that says if this job gets messed up, then all you're going to get is a full refund. I'm not going to pay to recreate your wedding. I'm not going to pay, if you're a mural artist, I'm not going to pay for another mural artist to come out here and fix this. What I'm going to pay for is is just your money back. So I like to think this is a reasonable provision because the clients didn't get any value, so they can get all of their money back. But also, you know, my client, the wedding photographer, shouldn't be on the hook for recreating the client's wedding so that they can have new wedding pictures, because that's really not what a wedding photography deal is about, because weddings are about more than just photos. So it's limiting their exposure. Whether or not it's actually reasonable would be something that a court would decide. And you can look at other cases to see if it looks in line with what's reasonable. But it's one of those things that's a little bit harder to know at the time that you enter into the contract that that clause is 100% going to be enforceable and protect you. So I also included another sample clause up here that would look pretty familiar to people who have bought houses, which is that the earnest money, and this is a new bill, this actually comes out of a Colorado Supreme Court case about liquidated damages, but the earnest money that the other party gets to keep your earnest money if you drop out, that's a form of liquidated damages too. So one contract could have multiple liquidated damages provisions, like if your retainer is non-refundable and it explains that your retainer is non-refundable because it serves to compensate you for lost business, that's a form of liquidated damages. And it doesn't always have to have the words liquidated damages in it to be a liquidated damages provision. Like this provision doesn't say liquidated damages, and it's still going to be subject to that three-part test I had on the previous slide. Why is it called liquidated damages? I don't know. It's a terrible name. But the way that I think of it is a way to say in advance that, hey, if somebody breaches the contract, if somebody doesn't meet their obligations, then the penalty, it's not really penalty, but then what they're going to pay is this. Okay, so the other two kinds of contract provisions that I'm going to talk about, and I'm going to talk about them together, and then I'm going to show you some examples, are indemnification provisions and liability waivers. So indemnification provisions, the reason I talk about them together is because they're really similar, but indemnification provisions are all about third-party claims, and liability waivers are all about the two parties to the contract. So in an indemnification provision, a really easy example of this is a graphic designer and a client. So a graphic designer's agreement might say that they will indemnify their client if they provide the client with materials that have another person's IP in them, if they violate somebody else's IP rights in those materials, and then that third party sues the client, the graphic designer will step in and cover the cost of the lawsuit, because the graphic designer is basically saying, I guarantee that I'm not violating other people's IP rights with the materials that I give to you. I am really careful about making sure that when my clients enter into agreements, that if they are asked to indemnify anyone, that they fully understand what that exposure means, because this is one of those things that can be expensive. And then liability waiver, a really good example of a liability waiver is COVID liability waivers. So I have a sample on the next page. But basically, before you participate in service or before you receive a good, you're saying as a condition of doing this or receiving this, I agree not to sue this other person or this other business for negligence that might injure me in the course of participating. And I bold negligence here because liability waivers can't protect you against behavior that's worse than negligence. So there's sort of a spectrum of, like law school language is tortious conduct, tortious bad stuff that people do that can hurt other people. Negligence is carelessness. Gross negligence would be like extreme carelessness. And then recklessness is like way out here. So like you can think of it as negligence is going 10 miles an hour over the speed limit. Gross negligence is going 20 miles an hour over the speed limit, and recklessness is exhibition of speed. That's not an exact science, but just so you understand, there's these degrees of bad behavior, and liability waivers do not protect you when you're out here. So liability waivers only work if you also act reasonably and take care. So I'm going to show the sample clauses really quickly, and then I'm going to go to the questions. So here's what an indemnification clause looks like. It does have this sort of magic word, indemnify. It doesn't have to. It could just say that they'll defend them in case of a third-party claim. But almost every indemnification clause has the word indemnify in it. And so that's one of those words when I'm reading contracts for clients that sort of is like red flag. Like we need to talk about this provision and make sure everybody understands it. So this is like a consultant. The client agrees to indemnify the consultant if the consultant provided the client materials. This is the reverse of what I was just talking about with graphic designers. And then here's my sample liability waiver. I should say that all of these clauses, I just pulled them straight out of contracts. These aren't like model clauses that you shouldn't just be like, this is great, I'm going to copy and paste it. I'm not guaranteeing them to be good. I'm just using them as examples. But I will point out in this COVID liability waiver, one strength of this liability waiver is that it identifies the risk. So courts prefer when liability waivers clearly explain to people what they're getting into and what risks they're waiving as part of the signing of the liability waiver. Okay. Meredith, I would be happy to take those questions if there were any.
I don't know if there were any coming in yet, though. I wonder if it's worth spending another moment on sort of the COVID specific stuff, both sort of to the earlier points about canceled events and how to handle that, as well as this sort of COVID specific language.
Sure. So let me talk about COVID liability first. So we are waiting for some federal legislation that might limit business owner liability for COVID transmission. I don't know. I don't hold my breath for Congress to do things. But at this current moment, the risk of getting sued for somebody contracting COVID at your business or at an event that your business puts on is absolutely out there. So especially my wedding venues, wedding planners, special event venues, people who are behind bringing groups of people together right now, I would like to see them use a COVID liability waiver. The good thing about getting sued for COVID transmission, if there is a good thing about getting sued for anything, is that it's going to be really hard for someone, a plaintiff, to win that lawsuit because it's hard to prove where you got COVID because it's out there in the community. There's plenty of ways that we could all get exposed every day. But the health department tracks outbreaks, and you can go on the health department website and you can see that there was a wedding at a particular venue that turned out to be a COVID outbreak. And if someone sues that venue, that's risk. So I like COVID liability waivers for people who provide in-person services right now, definitely like massage therapists. My dentist had me sign a COVID liability waiver before I got my teeth cleaned last week. The campaign rallies, to the extent that they're happening, are using COVID liability waivers. So there is some risk associated with anything in person. And I don't think it's a bad idea to use COVID-19 liability waivers if you are providing services in person or convening events. The other question about cancellations, I actually have a whole presentation about handling cancellations, but the issue with COVID-19 cancellations largely is whether or not it's a force majeure event. So force majeure is like, people also call it act of God. But if somebody is canceling your contract and they're saying it's because of COVID-19, the first thing that I want to find out as a lawyer is, did they cancel the contract because they didn't want the service anymore in light of COVID-19? In which case, to me, that looks like a client-initiated cancellation that likely your client will have to pay for in some way, depending on what the contract says. Or are they canceling the service because it is impossible to do whatever they were going to do because of COVID-19? And so early, like in March and April, anything in person was impossible. It was illegal to do. Now the only things that are really impossible are very, very large events. So the reason that distinction is so important is because if it's impossible, then usually you're under force majeure clause or majeure clause in a written contract. Then there's this doctrine called impossibility or impracticability or frustration of purpose. But under that doctrine, usually people are just excused of their performance. Whereas under your in specifically force majeure clauses, it's going to depend what your force majeure clause says. So it could still say that even in a force majeure event, the client's going to pay you at least X percentage. It's totally possible that's what your force majeure clause says. Way more common than it just excuses performance. If it's not force majeure, if it's a client-initiated cancellation, then often a good contract that is drafted on behalf of a creative small business will say something like, If the client chooses to cancel, then they're going to still pay, X percent of their balance that's due, or they're going to pay for X more days of services because the creative was relying on the client's business and the client made a promise to pay in full. So the creative should still be entitled to something to compensate them for that loss. So that's why that evaluation is really important. There's a lot more that I could say about COVID cancellations and COVID reschedules, especially for people in special events. But I'll leave it at that unless there are specific questions.
That's super helpful. Thanks, Allie.
Yeah.
And I'm just wondering if we can draw a parallel between liability insurance and contract clauses. I know I've seen public art contracts that require people to have liability, and the other way around. I think it depends on who's serving the contract, who's the buyer or the seller. But can you talk a little bit about the relationship there?
Absolutely. So with indemnification provisions, especially, if you have an indemnification provision in a contract, so I see these insurance requirements a lot for freelancers. So if a freelancer is entering into an agreement with a bigger business, so maybe they're a copywriter or a graphic designer, or public art is another good one where the city is really setting the terms of the agreement and then the artist kind of just has to meet the requirements. A lot of times the person with more bargaining power, the bigger company that's hiring the freelancer or the artist, is going to require the smaller guy to carry an insurance policy. So because if you are, a Fortune 500 company and you're hiring an artist to do an installation in your office, your general counsel knows that the artist isn't going to probably have a lot of capital in their business. Like if something went wrong and the artist caused some construction problems at your office, like created hundreds of thousands of dollars in property damage, and then the artist agreed to indemnify them because another person got hurt because of the damage that the artist caused, and that person's suing the company. And so the artist is saying, I'll indemnify you in that lawsuit, but if the artist doesn't have any money, then this indemnification provision does not help the company because there's no money. So oftentimes when there's an indemnification provision, there will also be an insurance requirement. And another common thing that I see in these insurance requirements is that you list the other party to the contract on your insurance as an additional insured. So that's just a way that usually bigger entities, doesn't have to be, it might be appropriate that you have in your contract. And I have worked with some wedding vendors who have subcontracted other wedding vendors and have required those people to carry insurance and to list them as an additional insured. But most often I see it when there's like a bigger company hiring freelancers or artists. And as a condition of coming on as a freelancer, you have to carry insurance and you have to list your, the person who's contracted you, the company who's contracted you as an additional insured on your policy. A lot of insurance, commercial insurance companies have really easy policies to add, really easy processes to add people as an additional insured. I had to do it a lot to get permits as a photographer. We had a lot of municipalities. Does that sort of cover what you were thinking, Meredith?
Exactly.
Okay.
Thanks. And I think that's all the questions we have for now. So I don't know, I think we may have one or two more slides.
Yeah, I do. I just have one more slide. And so the only thing I really want to wrap up on is, this is like my favorite New York Times article to talk about with small business owners, which basically I think it's really interesting that the doctors who are most likely to be sued aren't the doctors who have the worst patient outcomes, and they aren't the doctors who are the worst at their job. They're the doctors with the worst bedside manner. The doctors, and I don't know, if you've spent any time in a hospital, you've probably been treated by one or two doctors where they leave the room and you're like, oh my God, like, who is this person and why are they such a jerk? And like a year ago, my appendix ruptured, and like I'm still mad at the doctor that rounded on me on the post-op floor. But the reason I say all of this is because it's sort of this Maya Angelou quote of how you make people feel matters more in a lot of ways than how well you do your job. So I think a lot of times artists especially will get a rap for being kind of hard to work with. And I don't think that's well deserved. And I think that there are a lot of artists who are excellent at customer service, but to the extent that you're entering into business transactions, that you're an artist that also does business, you're not just selling your work in a gallery, but you are doing commissioned work, keep in mind that customer service is really important, and that being understanding of people when they're frustrated or when they have complaints, and treating people with professionalism and promptness and kindness. And even if you totally disagree with your client or with the person that you're in a deal with, making sure that they feel like you understand that they're upset and that you're acknowledging that they're upset and not being rude. That's like the best way to protect yourself from liability. In fact, if someone was like, should I provide good customer service or should I buy insurance? I'm only going to do one. I would provide good customer service. That's I think sort of the foundation to protecting yourself. And I don't mean to say that anybody should be a doormat, but what I do mean to say is that this consideration is really important. And I think creatives put a lot of passion into their work. And so I had the experience where I've had a dissatisfied client in our photo business, and I sort of immediately get really upset about it because it's not just transactional to me. Like, I put heart and soul into making that for them, and now they're treating me poorly or they're being unreasonable. So I always sort of try to just take a deep breath and put on my business owner hat instead of my creative hat, and think about what kind of outcome I want from the situation, and treat people with more kindness than I initially want to. So that is my last slide. I have a little bit of a brief summary about what kind of services I provide, but I'm happy to take questions if there are any.
I love that last point you had, Allie, about being kind and meeting people where they're at. And a lot of what you talked about in this presentation is really sort of stepping up the professionalism of your creative work. And I've heard a lot of pushback from artists over the years of how do I give someone a contract who's my good friend or who I want to pay me, and now I'm talking about termination clauses and liability. And can you just reconcile that a little bit about how to handle those two things, which may seem opposite?
Absolutely. So I just had this conversation this week, actually, because I was helping two friends who were like buying and selling a brand, right? One friend didn't want to operate the brand anymore, and the other friend wanted to take it on. So I was sitting with them and I was saying, like, look, I'm about to ask you a bunch of questions about what do you want to happen with this brand if you die or become incapacitated? And can you guys compete with each other? Like, can you go launch a competing brand tomorrow if you want to? And you're going to say, I would never do these things to my friend, or I wouldn't be worried about this. But my job as a lawyer, and what, even if you're working without a lawyer, what your job is as somebody who's looking out for your future self, is to look at any situation and to think about what happens in the best case and in the worst case. So, and what I mean by the best case is, what if this is wildly successful? What if I do this art installation and it just like picks up so much traction and it goes viral and everybody all around the country is obsessed with my piece of art? What protections do I need in that situation? And what protections does my client need in that situation? And what if this just becomes a disaster and we, through nobody's fault, we don't think about fault or blame, we just think about what happens if we aren't, it turns out we're not a good team. And those are hard conversations to have, but also I think both interpersonally and professionally, people appreciate it if you just say, hey, let's set all these expectations right now at the outset of the relationship. It's nothing personal. It's not because I don't trust you. I tell people all the time, blame me, say like, my lawyer said we should just answer these questions. And if people aren't willing to have those kinds of upfront conversations, you can tell what kind of lawyer I am because I've already quoted Maya Angelou. Now I'm thinking about Brene Brown and sort of just like, the boundaries are important to every healthy interpersonal relationship, including professional relationships. And if people are hesitant about you drawing boundaries or setting clear expectations, that makes me feel a little bit concerned. I think it's absolutely reasonable to negotiate over any term in any contract and to ask questions of people about any term in any contract. And if you're interested in this topic, you could read the book Getting to Yes, which is all about negotiating and talks about the interpersonal side of how to handle like these conversations when there's more than just business. There's also friendship or even just ongoing business relationships to maintain. But there's totally a psychology here. And yeah, I think it's important, and it is challenging, but the more you do it, the easier it gets.
Thank you so much, Allie. We're just at time. That was such a wonderful presentation. I think you provided a lot of very good tactical tips and information, but also, you know, hopefully put some people at ease on how to approach some of this work. So thank you so much for your time and sharing. I did put Allie's website in the chat, creativeslearn.com. We'll make sure that gets posted along with the YouTube link for this presentation.
Thank you.
So,
and yeah, follow me on Instagram. We do a lot of legal tips on Instagram if you're an Instagram person.
Yeah, Creatives Learn Law is the Instagram handle. And they're offering lots of other sort of trainings and informational pieces there. So yeah, thank you for joining us. Please make sure you're also following CBCA and Colorado Attorneys for the Arts. We have lots of other great webinars and trainings, resources, our referral service that's available to you all as artists and creatives. Thank you for what you're doing. These are tough times, and we need the arts now more than ever. So keep up the great work and have a wonderful rest of your day.
Great. Thank you for joining, guys. Thanks.